YouTube, it's Tom back with another one for you. This one here is continuation of Court Survival Guide number 8. It's the 8th video on that. There's probably a few more to go. So this here gets into what it would be if you got past all of the initial litigation and then moved your way toward trial, and what it would look like picking your jury and shit like that. So let's get into this, but that's more toward the end. So, if they try to pull off any of this fraud, expose it immediately and shoot down their lame excuses. Get it all on tape, tell them that there is no law which compels you to waive your constitutional rights. Tell them that there is no law which compels you to obey any of their rules which apply to licensed attorneys, because you have no such license or oath to the Bar Association. You are going to conduct your case according to how you see fit, as your own pro se defense counsel. So tell them that there is no law which prohibits the jury from being informed of the truth, their full rights, and their power of authority. If they want you to even think that there are such laws, they will have to show you where they have them written, where the written law is. So if they put up a fuss, demand to see their licenses, green cards, or titles of nobility, now that they're trying to use their secret treasonous tricks against you. If they insist they are right and that you have to obey the rules that the judge dictates to you, then demand to see such rules to back up their bluff with legal evidence. Otherwise, tell them that they can forget it. Ask them what they are attempting to hide. They may avoid your questions by stating that they have no time to answer them. No problem. Just tell them that you have no time to conduct your defense until your questions are answered, and sit on them. You can wait longer than they can. It's your trial. And it's your neck on the line. You have infinite time. And that's a fact, too. We should underline that. You do have infinite time. In general. I don't know about court, though. So then look them straight in the eyes and tell them that what they are doing is fraudulent and illegal. And now that they know that you know, tell them that you will expose their fraud in court on the record if they dare to even threaten you with contempt of court for exercising your rights. Tell them that they could both easily be facing charges of treason and conspiracy to commit fraud and treason, and breach of trust, and so many other things. So when all the truth has been exposed, then tell them that their entire conversation is on tape, and watch them sweat for a change. The judge or prosecutor may then offer to dismiss the case right there. Just make sure you give your hot tape to a friend for safekeeping when you walk out of the judge's office. Oh, they're going to regret being in court with you, by the way. So strategy 3. Reserve all your rights up front. This is your insurance policy against any attempt by the judge or prosecutor to force you to waive your rights. So all you do is reserve them up front when you first enter the court for jury selection and on the record. This way you can still eventually win the game, even if you go all the way to appeal. So then, when it is your first turn to speak, you get up and announce your intent to make a reservation of rights. Just read your list of every right that you feel applies to the conduction of your defense. Use the list at the beginning of this guide as a start. Use the Constitution if you have to. I would use the state constitution, by the way, which are in the Promissory Estoppel contracts. It all has your state constitution in there, which is what you want to stand on. All right, if you're talking about your rights, you want to talk about that. The U.S. Constitution is going to be the government's limitation. So if you're going to use that, you're going to use that toward any errors that they're making and apply it toward that, not toward your rights. Your rights come from, number one, God, but then two, they're going to come from your state constitution, not the U.S. So make sure to include freedom of speech, the right to fair trial, the right to an unbiased jury, the right to legal counsel, the right to be informed of the nature and cause of the accusations, the right that all evidence being used against you, including contracts, be placed in evidence by the court, the right to call witnesses, the right to introduce evidence, the right to travel, and the right to life, liberty, and the pursuit of happiness. This way, if the judge should instruct you not to do something, i.e. waive your right to do it, you can then remind the judge that you have already reserved your rights and then force him or her to make a judicial determination whether you have those rights or not. You can just catch them in the act on record. Get it? So you want to get everything on the record. So, okay. Your valid and explicit reservation of rights removes any implied consent, so they will still want to pursue the case against you. Then you must demand that the court now place in evidence a document nexus or matrix or connection point is the nexus, or some legal instrument which binds you to the state of the forum, e.g. a contract that you sign, since it's all admiralty and commerce, right? So as required by UCC 3-401, which requires your compliance, and they're all commercial entities, so they're going to be governed by UCC. So if you are not bound to the state of the forum, you are basically a non-resident to the court. Which is crazy, because how are they even gaining jurisdiction on non-residents? Which means that you're not actively engaged in commerce if you're a non-resident. It means you're not engaged in commerce. So here we go. So the jurisdiction. So if they don't cough up the evidence, then motion for dismissal by default. If your motion is denied, then motion for discovery to place the missing documentation in evidence. Make them work for it. Tooth and nail, tooth and nail. So strategy 4, inform the jury by cleverly questioning. So this is assuming that the jury's there and you're questioning them to see which ones are going to be best for you. So inform the jury by clever questioning. So you got to keep in mind too that when you speak, you can speak in rhetorical questions just for the point of getting a point across without actually having to be a statement. So you don't have to say this is what they do too. So this is where you carefully construct your void dire questions so that they inform the jury of their true and full rights, their true function in the courtroom, and knowledge of their full authority and power, yet so cleverly that you are not charged with contempt of court. You want to select a jury that can understand the real issues and see that you really represent them as people. You see, the problem is that the judge and the prosecutor cannot afford to let the jury know what their rights are or their true power of authority, because then they would lose their control and false authority over them. They want the jury to be just as fearful and ignorant as possible so that they will do what they are told, find you guilty, and be all done and home in time to make dinner. Another problem is that there is a relatively large amount of information to convey in a small amount of time to do it. Plus, they will be nowhere near as knowledgeable of the truth as you are. So the best way to use this strategy is to ask every juror one by one all of your questions so that they will all hear the information contained in the question at least 12 times each. Make a box diagram of 2x6, i.e. 2 rows of 6 boxes, so you can write the name of the jurors when they are introduced, so you will know them and address them by name. You want to establish a good rapport. Here are a few good questions. Number 1, Mrs. XYZ, as a juror, do you feel you are an instrument of the court or an instrument of the people? Number 2, Mrs. XYZ, are you here because you feel a civic duty to vote your conscience, or are you here because you feel threatened by the law if you don't comply with the court's wishes? And that's funny too, because nobody wants to go to jury duty, but they all feel obligated and shit. And you don't want somebody like that sitting on your case. You know what I mean? So number 3, Mrs. XYZ, are you aware of that? As a juror representing the people, you are empowered to vote completely independently from the rest of the jurors. Mrs. XYZ, are you aware, as a juror representing the people, that your single vote of not guilty is enough to acquit me of all the charges? And that's the thing. So every single juror has to find you guilty on that thing too. So that's the thing. You want to raise as much reasonable doubt as possible, which is real fucking easy to do, to be honest with you. And you just gotta know your shit. So number 5, Mrs. XYZ, are you aware that as a juror representing the people, you are empowered to vote your conscience regardless of anyone else's coercion or instructions, including the judge? The prosecutor is likely to object. So this is a thing. They're gonna want the jurors to think that they have to that they're bound to rule based on the corny jurisdiction that they're operating under. When in all reality, if the people had any sense, they would just probably throw the whole case out initially, right? So Mrs. XYZ, how do you feel about jury duty? Service, duty, honor, drudgery. Mrs. X, how do you feel about jury duty? Basically asking them, how do you feel about even being here? So Mrs. XYZ, do you know your full rights and power in this court? Mrs. XY, and then ask them what they are. If they say yeah, that they know their full rights, ask them to make sure that they know, so you know who's sitting there listening on your case. So Mrs. XYZ, do you know that you are entitled to and authorized to vote your conscience according to your own sense of right and wrong? Meaning that you're not going to go there and just go based on codes and statutes. You're going to use your common sense, morals, and shit like that, which are all programming, but for the most part, people are good. You know what I mean? So if they have a good conscience and good morals and shit, you wanna find out what they are. So Mrs. XYZ, do you know that your decisions override the judge? More power. So, you're putting them in a position to let them know who they really are. Because, a lot of people are in there not because they want to be, but because they feel obligated to be, because they got that jury duty letter. So this is letting them know who they are without really telling them. So, Mrs. XYZ, do you know that you are above the law, not constrained to law or facts, or that you have the right to judge the justice of the law? See, and this is really putting them in a position to understand who they are, and so they can really see what's happening right there in front of them. And it's kind of knocking them out of their little trance. So number 11, Mrs. XYZ, do you know that you have the right to acquit and nullify any law that you feel is unjust, morally wrong, or not serving the people? And that's the biggest thing here, is that the government was established essentially by the people to work for the people, for the benefit of the people. And it seems to have gotten really fucking, really twisted. Really twisted. So completely inverted. So note above that the first question deliberately puts each juror on the spot for questioning and deciding their true purpose as a juror. Unfortunately, very few have any idea that they are duped into being mere instruments of the court, thereby proving the jury to be a robot extension of the judge's orders. So why have a jury at all if they are programmed to do what the judge says, and why even have a jury at all if they are programmed to do what the judge would do on his or her own without a jury? So that's the thing. So, if the jury is ignorant of the law, then there's pretty much no point in even having one, because they're just going to do whatever the judge says. So the answer is that although the jury was originally intended to bring the conscience of the jurisprudence into the court as a check against the tyranny, the court still needs them to make a showing a political appearance. So yeah, it's just a fucking theater, really. So if you observe the questions above, especially the first one, that the jury simply does not really know what their true function is or what their full rights are, you now have every reason to refuse the jury for cause, because they are not your peers. They do not understand the issues as well as you do. They don't even know what their civic responsibilities are. Why are they there? If anyone complains, you may ask, why should the people of XYZ, represented by the jury, believe only what the judge tells them? The judge is only a government employee working for the people. How can we possibly guarantee that the judge is telling the truth and the whole truth and nothing but the truth, right? So there's a lot of reasons why they wouldn't be telling the truth. So also know how all of the questions inform the jury that something is very wrong with what they have been told by the courts. Your jury will be deciding the case, but unless you educate them, they will just follow the judge's fraudulent directions to vote according to the laws dictated to them. So this is why you need an informed jury. And that's what I'm talking about jury of your peers. You know what I mean? Like, there's so many different forms of programming, even in one little area, that there's no guarantee that everybody's even on the same page. Like, this fake ass government's whole goal the whole time has been to cause freaking division, and they do that shit really, really well. And even in a small freaking community, they can chop people into smaller and smaller boxes so everybody feels alone and shit. It's crazy. It's fucked up. So crazy mind control. So there are many informed jury pamphlets and reference books to utilize this, as we suggest you find everything you can on the subject so that you can walk into the court with your questions fully prepared. You will have to word the questions such as you don't upset the judge enough to charge you with contempt. Fuck them if you can't take a joke, to be honest with you. So strategy 4A, bait the prosecutor with your jury's questions. This strategy, combined with number 4 above, gets right down to the heart of their fraud. It is complicated because it is your most powerful technique, and because it undermines the very critical foundation of their tyrannical control over the jury and outcome. So you must study this carefully. It could easily win your case regardless of the charges, and they're not going to give up easily. So this could be your most skillful technique still available in cornering the judge. So when the prosecutor objects to question 11 above, it will happen when the prosecutor will choke on the word nullify, because he or she can't afford the jury to know their rights. You must immediately challenge their efforts to silence you. You must motion to dismiss on the grounds that the prosecution has compromised the accused Sixth Amendment right to an independent jury, taken from the cross-section in the community, which reflects the norms and values of the, let's see what it is, community, I think it is coming up. Yeah, because, I mean, like, part of their job is to taint the jury, too, if you keep that in mind. The community. The denial of independent jury infringes upon the procedural due process of the Fifth Amendment. 2, if your motion is denied, explain to the judge that there is no law which prohibits the jury from knowing their right to acquit and nullify laws that they disagree with. According to conscience, press the judge into explaining why he or she is deliberately keeping the jury ignorant. Object if the judge evades the question. Number 3, if the judge orders you to discontinue this line of questioning, then ask the judge for clarification. If he or she has indeed made a judicial determination that the jury is prohibited from knowing their rights to acquit and nullify the law, if no, then the case must be dismissed because the prosecutor's objection above. If yes, then the motion for a finding of fact to prove or disprove the judge's bluff, he or she must now place legal proof into evidence that somehow justifies the fraud. Corner the tyrant. The judge is trying to deceive everyone that his word is law, because he or she says so. Yeah, fucking right, bro. So number 4, if the case is not dismissed, the motion denied, then look the judge straight in the eye. look the judge straight in the eye, objects, put him or her on notice that this is a treasonable judicial error and that you intend to appeal it. Then move for dismissal. The jury is now obviously no longer impartial because they just witnessed that whole bullshit. So I mean, that is a fucking, so they would have to start all over if you have this conversation in front of the jury. I'll tell you that right now. So then move for dismissal because the jury is now obviously no longer impartial as required by the 6th Amendment. If this does not work, then refuse the jury for cause because of their obvious bias against your defense, right? Because of their brainwashing. So number 5, which is obvious. If the judge then tries to pass the jury for cause, essentially ignore your motions, inform the judge that he or she may be practicing law from the bench. Then motion for a finding of fact to determine if the judge can legally get away with it, right? Pull out the books, man. Pull out the fucking books. So strategy 4B, make a First Amendment political jury speech. This is also a trap that you set for the prosecutor used in conjunction with strategy 4 above. As soon as you start informing the jury, without questions, the prosecutor will object. Of course they're going to object because you're blowing up their whole shit in front of the jury. Do they really got time for that? So when the prosecutor objects, the motion for the judge to make a legal determination as to whether the political speech or jury nullification is a direct disruptive influence on the judicial matter at hand. If yes, then call the bluff and move for a finding of fact. Make the judge squirm to justify his or her fraud. If no, then say thank you. Also, Your Honor, I reserve my rights as politically protected speech to inform the jury during opening statement, closing statement, and trial to disregard the substance of the law and the matter at hand pursuant to the 6th Amendment guarantee that the jury be the judges and the fact and the law. So, number 2, if your motion is denied, then refuse to pass the jury for cause because of the corrupted independence of the jury and bias in the favor of the prosecution, which will be pretty obvious once you start asking them questions. So number 3, if judge tries to pass the jury for cause, essentially ignoring your motions, inform the judge that he or she may be practicing law from the bench, then motion for a finding of fact to determine if the judge can legally get away with it. Strategy 5, seed the jury before trial. This is an arrangement you can work out ahead of time, but only if you know someone on the jury list. The definition of the jury of peers includes people who you know in the community. The people who, the problem comes when the judge and the prosecutor unfairly violate this by dismissing jurors who admit to knowing you. So worse is when a juror admits knowing you, the prosecutor then proceeds to insult and abuse their honesty by asking about intimate and personal details unrelated to the case. They just aren't playing fair, so neither should you. Your friend selected for the jury duty might just want to show up and pretend not to know you and then vote not guilty. Of course you can do that. So simply because he or she knows that the truth and that this is one way to neutralize the court's fraud. The truth is that there is no law which prohibits jurors from knowing the accused and no law which prohibits any juror from knowing that they can vote not guilty for the purposes of acquittal and revoking a bad law. So strategy, and I mean, that's a thing that I think a lot of them are not told. And I mean, you don't want me on the jury, bro. So strategy 6. Submit your own jury instructions. This is where you place the truth in front of the judge and prosecutor and then watch them squirm out of allowing the jury to read it. You and your opposition will be formally reviewing and agreeing on each of the instructions the jury is going to be allowed to read. It is another phase of the game that's rigged against you, but you can make sure that all of their fraud and bias against you gets onto the record. Make sure your instructions are each typed up on separate pages and make copies available for the judge and prosecutor. If you have not had enough time to review the prosecutor's instructions, then say so. Demand motions to postpone the trial until you have been given adequate time to review the prosecutor's instructions. It's your pro per right as your own defense counsel. Don't let them railroad over you. So number 1, ladies and gentlemen of the jury, you are instructed. No juror can ever be punished for his or her vote. God and the juror's own conscience is the only authority. Number 2, ladies and gentlemen of the jury, you are instructed that never yield your sacred vote in favor of peer pressure or majority. Your own conscience is more important. You are not here to simply agree. You are not here to rubber stamp. Number 3, ladies and gentlemen of the jury, you are instructed that the only power that the judge has over the jury is the power of intimidation and what he doesn't tell you. It's not real power. Don't give yours away. So number 4, ladies and gentlemen of the jury, you are instructed that a single final vote of not guilty is all it takes to nullify any unjust or questionable law. So number 5, ladies and gentlemen of the jury, you are instructed that this is where the people have more power than the president, and your decision is irreversible and irreproachable. Number 6, ladies and gentlemen of the jury, you are instructed that the prosecutor must prove to you guilt beyond any reasonable doubt. This means that if you suspect that anything is wrong with the picture as presented to you, I must be innocent and not guilty. Number 7, ladies and gentlemen of the jury, you are instructed that the jury gets to decide what reasonable doubt means. I mean, it's pretty, look at the fuck up in the dictionary. Why is it open to somebody's interpretation of what reasonable doubt is? It means that if you're not 100% convinced, then there is reasonable doubt there. So, ladies and gentlemen of the jury, you are instructed that the jury is the acid test of whether or not the government system is really doing its job of the people, by the people, for the people. And it is really up to them, you know what I'm saying? And you know, the sad part is that you'd be hard pressed, I think, to be honest with you. You'd be hard pressed to find anybody that really knows the law, because it's so fucking multifaceted and fucking ridiculous. So, number 9, ladies and gentlemen of the jury, you are instructed that the judge may not instruct and pressure the jury that they must reach a unanimous decision soon, meaning that everybody has to agree, with some false concern for burdening the taxpayers. Ladies and gentlemen of the jury, you are instructed that thinking if the jury was constrained to the letter of the law as dictated, if the jury was constrained to the letter of the law as dictated by the judge, we wouldn't need a jury to begin with. That's the judge's job. And that's the thing. So you have to be able to think different than the judge does. So it really doesn't matter what the fuck that he's even talking about. So, ladies and gentlemen of the jury, you are instructed that there is no law or court decision that has been decided that jurors do not have the power to acquit and nullify despite the law or the facts of the case. This would comprise tyranny and destroys the purpose of the jury. Number 12, ladies and gentlemen of the jury, you are instructed that the jury has irreversible power to acquit and nullify the law for whatever reason it deems appropriate. Number 13, ladies and gentlemen of the jury, you are instructed that jurors not only have the right, but also the duty to nullify bad laws by voting not guilty. Number 14, ladies and gentlemen of the jury, you are instructed that no jury should, in principle, vote against his conscience and later have misgivings and or apologies for the accused. So 15, ladies and gentlemen of the jury, you are instructed that the writers of our Constitution defined a jury as a group of citizens who were to judge the rightness of the law and as well as any facts in any case according to their own conscience. So 16, ladies and gentlemen of the jury, you are instructed that our Constitution has set up 5 tribunals with the power to veto any law: Senate, House of Representatives, Executive, Judicial, and the jury. The jury has the final say in the letter of the law. 17, ladies and gentlemen of the jury, you are instructed that our forefathers intended for the jury to serve as one of the tests of law must pass before it assumes enough popular authority to be enforced. Which is crazy because they're over here passing laws without any popular vote. It's really just like three or four people that feel a certain way. And they just sign a piece of paper and they're like, hey, you guys are bound by this shit. Yeah, right, bro. So 18, ladies and gentlemen of the jury, you are instructed that the base of all governmental power was established with and always intended to remain with we the people. Remember, of the people, by the people, for the people. 19, ladies and gentlemen of the jury, you are instructed that if a juror accepts as law that which the judge states, then the juror has accepted the absolute authority of a government employee and thereby has surrendered the power which made it meant for the people. So 20, ladies and gentlemen of the jury, you are instructed that remember that it was bad laws, forced martial laws, corrupted courts, taxes without consent, and deprivation of rights that brought our ancestors to this country to begin with. And look what the fuck happened. Look what the fuck happened. So, you know, these are things that you need to know. So you know what to expect if you ever end up in any court litigation and then end up in the point to where you weren't able to work things out, whether through equity or law initially, in the initial stages, then you end up having to go to trial and exposing their whole shit in front of the jury. So, you know, we all got choices. I would pick your battles and use your head. So, it is the game of chess. Stop playing checkers with these clowns. That's what I got for you for now.